government has looked at it. They have extensively looked at the recommendations. Now they have to tell us which of those recommendations they accept.
Which ones they do not.
Which ones they accept but with modifications, and which ones they do not accept. Now, whatever they have decided has to be now published alongside what the Constitutional Review Committee...
So that the Ghanaian can
then we
decide
can look at
side by side.
Of course, because that's not the end of the matter. Now they have to... Government has indicated that they are going to set up a constitutional a committee to look at the implementation. So I'm sure the implementation committee at that stage will take in inputs and all that. And if Ghanaians, remember, because power emanates from us, and that constitution is for us, and it should be from us. So if we disagree with the government in terms of some of the things that they want to reject, some of the things they want to modify, perhaps there would be another room for us to look at it. But by and large, it would be disingenuous to think that the constitution as we have it now does not need some tweaking. Certainly it needs some tweaking, and I think it is long overdue, and I hope and pray that this time around we won't come all this way, all this far, and then end up in the same, if you like, blueprint that we have had previously.
So you talked about framers of the Constitution, and this current one, the 1992 Constitution, having traveled 30 plus years, was framed by a certain narrative in a certain regime. How do we ensure that in 2026, national interests supersede perhaps interest of the government of the day when it comes to conversations around amending the Constitution? Because we want to ensure that everybody's interest, not just the interest of the regime of the day, is represented and protected in that document.
Well, I mean, it's not even wholly accurate to say that it was the regime previously that got us the 1992 Constitution. Because if you look at the whole journey of bringing up the 1992 Constitution, it was very comprehensive. Almost every identifiable, association was asked to send a representation, and then they sat down and they looked at it and they went through processes, because that's the whole idea of the Constitution. And the same way, when you're going to do an amendment or you're trying to make any recommendation, you can't stay in your small corner and just spring something on us. That's why the Constitutional Review Committee was set up. And they went around almost all the country and invited some very important stakeholders to come and make input. I remember myself and a few colleagues, we went and made representation on behalf of the concerns we have regarding media freedom and independence, and the way 30 years down the line it is being abused and is being applied. So we made that, submissions. Of course, they took some on board. They might have rejected some. So that's the whole idea. It's not just a small group, because you can't do that, because it's for everybody else. So that's why this process, the fact that they have printed the recommendation and government says, we have looked at the recommendations and this is what we are accepting, this is what we are rejecting, this is what we are going to modify, is going to be subjected again to some sort of public scrutiny and all that. And thankfully, we have a very vibrant media now, and these things are going to be open and transparent. Anything that has to do with guiding us, we need to have it done in an open and transparent manner, because that is the way everybody feels they have a stake in bringing up that document that is going to be binding on you, whether you like it or not. And that is why, ultimately, the ones that had to do with the entrenched clauses, about 40% of people who are eligible to vote have to vote.
They have to
and
show
70%
must say yes.
Of them must say yes. If they don't say yes, there is a problem. And then when it comes to even the ones that is not entrenched, it has to go through what? The people's representative, which is members of parliament. So it goes through almost every stage of the way. Either there would be a direct representation of the people or indirect representation of the people through the people's elected representatives. But of course, we, the media, will still have to keep an eye on that, because whether we like it or not, there may be some sort of issues about political actors would always want to look at what is it that may not inure to me and all that. But I always say that when you talk about constitution, we are talking about 30 years down the line. So don't think about it from a very parochial interest in terms of today. You need to look beyond you and the fact that these things are not things that are tinkered with easily. And therefore, when we are doing it, we do it with the public interest at heart, with the public interest in mind. What is it that we need as a guiding document that will serve us for a long period of time without necessarily having to go in there all the time and try and tinker with it.
When I mentioned interest, there were those whose key challenge with the 1992 Constitution was the fact that it was framed in the PNDC, NDC early days, where a military government was transitioning into a more democratic system. And so whereas the Constitution allowed for some freedoms, the power was largely still held by one arm of the government. And then the proposals were that these powers should be disseminated more broadly to ensure that a kind of, dictatorship or authoritarianism is not maintained and perpetuated going forward. And that's why I asked about interest. And I'm glad that you raised the series of consultations that have gone on and an inclusive nature in which it has. So then I guess my problem is, should the new reforms solve today's problems necessarily, or should we just make it ready to serve us for another 50 years and look to reform it again several years down the line or further down the line?
Well, when you're looking about reforms, you're not looking at reforms. You're, of course, looking at reforms based on where you're coming from, where we are now, and where we want to be. And remember, we are not in this, we are not living in a small village. Now it's a global village. We have seen some sort of, if you like, blueprints of other constitutions and how it has served them. We have seen some blueprints of other constitutions and how it hasn't served them. We have seen ours as well. So certainly it's not going to be to address an immediate problem, because that would be defeatist. It's looking at where we are coming from, where we are now, and where we are going. Certainly, somewhere along the line, things may come up in this fast-paced technological era. Things may come out that may need us looking at provisions in the Constitution to align with the times. But certainly, you don't do that now. Because, for instance, if you look at some of the recommendations that the Constitutional Review Committee made in terms of the media, now they are trying to get the Constitution to define when we say media, because now media goes beyond the traditional media that we know. And so they are looking at it in a more progressive manner. So this is how some of these things are going, because now you have other institutions. For instance, UNESCO is telling us now when you talk about media, when you talk about journalists, don't look at actually the profession, look at what role they are performing. And therefore, if people are performing functions almost similar to that of the media, can you deny them that? So whatever we are going to do is going to be forward-looking, of course, but bearing in mind that this is where we are coming from. If it's not forward-looking, then it is defeatist. And that is where the issue of parochial interest would come in. And you are absolutely right when you said that ushering in the 1992 constitutions, of course, there were a number of give and takes because of where we are coming from. But that is, if you don't acknowledge that, then that is you being part of the group who think that democracy is a purer than pure system of government. No, democracy is not a purer system of government. Therefore, anything it produces will not be imperfect, but you have to find ways of mitigating the imperfections as you go along. So yes, during those times, there were reasonable bases for allowing some of these things into the Constitution, because you look at the bigger picture. Do you allow those sort of compromises for us to move from a military era, or you don't allow, and then you make those people hold on to the position of not transiting into a democratic era? And we saw that around the African continent, where people refused to transit. But because of some of those, if you like, concessions, we saw the journey back into the 1992 constitutions and where we are now. I think that why we have found ourselves in here is because of our failure or refusal to try and change some of those provisions long ago when they started rearing their head. And it's all because of, if you like, the parochial interest, where sometimes, because we are talking about power, and some of the recommendations of the Constitutional Review Committee is talking about trying to diffuse the power that is almost centralized. And you know, when you have power, when they give you power, it is not going to be easy for you to relinquish that power. You will come fighting.
Not at all. And whilst the full report for the Constitutional Review Committee, we've been promised the full report will be made public after the Dr. Ayine's broadcast or his briefing. But we do know that what has been going around in media circles are the proposals that have repeatedly been reiterated across platforms. And I'm glad that Lawyer is here. Very soon we'll be joined by our second guest, and we'll get into some details. So one of the key things we'll be looking to hear from the white paper, Lawyer Tanko, is about the presidential term, the attempt to extend the presidential term from 4 to 5 years. Like you've mentioned, the separation of Parliament and the executive, which would mean that it would remove the requirement allowing for ministers or a percentage of ministers to be appointed from Parliament. Creating a clear separation of powers will also be something that we'll be looking forward to hearing the government's position on. The appointment of MMDCEs is also quite topical, so that the president no longer has to nominate or go through the number of CVs that no doubt crosses his desk at that time of those times of the year. Yeah. And so giving the power to the people to choose their own MMDCEs. So even these 3 points are something that we would clearly be looking forward to hearing from the government on.
Oh, certainly. Almost all the presidents we've had in the Fourth Republic have, at the tail end of their tenure, have raised the issue about whether or not the 4 years, it's something that really is serving as well. Because if you look at the whole architecture, you elect a government and they spend almost about 1.5 years trying to put government together and all that. And then after they put the team in place, they start working, and then we are just almost close to another elections. And when elections is rearing its head, nothing gets done and all that. So there had been that argument. But because of the skepticism that has been introduced in our body politic by these 2 main political parties, it looks like anytime that recommendation is made, it is treated with that sort of disdain and contempt.
Today there is that opportunity, and let's cross over. We understand that the signal is ready. Let's cross over to the Jubilee House, where the AG is going to make the press briefing on the government white paper on the Constitution Review Committee now.
Or give reasons why it will not publish the report of the commission or committee of inquiry. The position of government in respect of the recommendations of the committee is formulated in 3 ways. 1, either we are accepting, that is, government is accepting, or 2, it is accepting in principle subject to modification, or 3, it is rejecting outright the recommendation of the committee. Where government accepts the recommendation of the committee in principle, that is subject to modification, we provide reasons why we seek to modify the recommendations. Reasons are also accorded where government does not accept the recommendations of the committee. In formulating the position on the final recommendations of the committee, government examined each recommendation against the relevant provisions of the 1992 Constitution of the Republic of Ghana to assess the nature, scope, and implications of the proposed amendment. Each recommendation was then subjected to rigorous constitutional and legal analysis, including whether it touched on entrenched or non-entrenched provisions of the Constitution, and whether its underlying objective could be achieved through other legislative or administrative means. We also examined the recommendations in light of the work of prior constitutional reform commissions or committees, such as the report of the 2010 Constitution Review Commission, in order to ensure continuity and consistency in the reform process. As I've noted earlier, when I submitted a draft position paper to Cabinet, extensive deliberations were held and each recommendation was interrogated, weighed against the practical experiences of our country, and refined before Cabinet granted approval to this position paper. I have underscored the importance of this process in order to highlight the fact that the position paper being published today is not the product of one ministry or one department of government or a group of technocrats sitting somewhere in a corner and working at it. On the contrary, it is the product of the considered thoughts of the men and women who have been given the honor by His Excellency the President to run the affairs of our country within the executive arm of government. Before I turn to the highlights of the recommendations accepted or not accepted by government, indulge me a little to explain the principles that guided the formulation of the government position paper on the final report of the committee. First, government took the view that the Constitution is the supreme law and that any attempt to amend it should be done carefully. Therefore, recommendations that were considered insignificant in terms of their normative value were not accepted for constitutional amendment. The Constitution is the statement of our foundational values and structure, and not an operations manual designed to troubleshoot every problem in our society. Secondly, and this flows from the first consideration of principle, only changes that definitely required constitutional amendment were considered. Where the objective of a proposed amendment is best achieved through ordinary legislative or administrative means, a point that I have made earlier, government chose the alternative route. This approach was also animated by the fact that an ordinary statute can be amended by Parliament as circumstances change. It is not so with the Constitution of the Republic. My fellow countrymen and women, permit me now to turn to the highlights of what the government thinks is doable and in the best interest of the nation. That is the accepted recommendations. The government has accepted a recommendation to extend the term of office of the President from 4 years to 5 years, with a term of Parliament extended to correspond with this. Our thinking is practical. Under the current 4-year cycle, the early months of every administration are consumed by transition matters, and the final year is largely consumed by elections. A 5-year term provides a more realistic time frame for the formulation, implementation, and assessment of government policy. Still on the presidency, the committee recommended that the minimum age of eligibility for election as president be reduced from 40 years, currently in the Constitution, to 30 years. The government has accepted this recommendation in principle, subject to one modification. The minimum age will be 35 years, not 30 years. And of course, the details of this will be fashioned out by the Constitutional Review Implementation Committee. The current threshold of 40 years excludes qualified citizens from seeking the highest office on the basis of an arbitrary age limit. 35 is consistent with a trend in modern democratic constitutions towards greater inclusivity of the youth, whilst ensuring that a candidate for the highest office has attained a measure of maturity and experience to handle that office. We have also accepted that the presidential election be held on a day in the first week of November, as the Electoral Commission may specify by constitutional instrument. A fixed period gives certainty to the electoral calendar. It allows the Commission, the parties, and observers to plan, and it ensures an adequate interval between the election and the inauguration of the incoming president on January 7th. On presidential election petitions, the government has accepted that a petition must be filed within 14 days of the declaration of results and determined by the Supreme Court within 30 days. In other words, the Constitution will be amended to specifically provide for these timelines when it comes to the electoral petitions to be filed. And there is going to be a constitutional obligation on the part of the Electoral Commission to disclose all relevant data to the court and to all the parties. We take the position that this position because the timely resolution of election disputes inures well to the stability of our democratic transitions and to the general political stability of our country and society. The government has also accepted the principle that the president should not enjoy tax exemptions by virtue of office alone. The president will pay taxes on his salary and allowances, as well as the applicable indirect taxes on goods and services. The government has not, however, accepted the proposal to tax the president's retirement gratuity and pension, and the details of the president's tax liability will be worked out in the tax laws where such details belong. On Parliament, ladies and gentlemen, the government has accepted that the size of Parliament be capped before I go to Parliament, there is the issue of ministers of state and the number of ministers of state, which is one of the very, I would say, thorny issues that has bedeviled our democracy for some time now. Government has accepted the proposal to cap the number of ministers, but instead of 57, as the committee recommended, government is proposing that it should be capped at 60. So it will be put into the constitution that the number of ministers that any president elected by the sovereign people of this country can appoint will be only 60, and they may or may not be drawn from Parliament. Now, to Parliament, the government has accepted that the size of Parliament be capped, and we propose a ceiling of 300 members. Now, the current membership of Parliament is 276. So of these, the 276 will be elected directly in constituency elections like we already have. The remaining 24 will be elected or selected through proportional representation among women, persons with disabilities, and the youth. An independent study will be commissioned into the design of the proportional representation element. Capping Parliament saves costs, and the reserved element opens the door of our legislature wider to those our politics has historically kept on the outside. The government has also accepted a recommendation on dual citizenship. A citizen of Ghana by birth who holds the citizenship of another country will no longer be barred from contesting for election to Parliament only on account of his or her dual citizenship, and will not be required to renounce the other citizenship. The current disqualification sits uneasily with our engagement with the diaspora and with the realities of modern citizenship. In line with this proposal, it is also the case that multiple citizenship will no longer disqualify a person from becoming, from holding certain, offices, except that of President and Vice President of the Republic. So the fact that you have multiple citizenship will not bar you from becoming Chief Justice of the Republic or becoming the head of the Electoral Commission or, for instance, becoming Speaker of Parliament. On to the judiciary. Regarding the judiciary, two positions deserve mention. First, the government supports a fixed tenure for the Chief Justice. That is a single, non-renewable term of 10 years or until the age of retirement, which currently, whichever occurs first. And the age of retirement of justices of the Supreme Court now is 70 years. So if these amendments come into force and a person is appointed Chief Justice, that person will serve a 10-year non-renewable term. However, if the person's retirement comes first, the retirement will take place and the person will have to exit as a Chief Justice of the Republic. The second thing that I want us to note about the judiciary is that the government supports capping the Supreme Court's membership. Currently, the committee recommended a cap of 15 justices. The government proposes 19. That is the Chief Justice and 18 justices of the Supreme Court. Now, this cap promotes efficiency, manages public expenditure, while the bench of 19 remains sufficiently robust to discharge the court's constitutional mandate. On political parties, the committee recommended an amendment to Article 55 to require every registered political party to afford its members in good standing equal voting rights in the selection of its parliamentary and presidential candidates. The government has accepted this recommendation. Just yesterday, as you recall, the Supreme Court, in the case of Professor Frimpong Boateng and others versus MPP, NDC and others, held that all registered members of political parties should be allowed to take part in their internal elections to select the presidential candidate as well as the parliamentary candidates. And therefore, on this question, the committee, government, and the Supreme Court now speak with one voice. Political parties are the vehicles through which we choose those who govern us. In fact, they are public entities, and they cannot themselves be governed just by a few. Relatedly, the committee recommended an independent body to register and regulate political parties in place of the Electoral Commission's current role. The government accepts this in principle. However, we prefer that the designation Political Parties Regulatory Commission be the nomenclature of, instead of a registrar and regulator of political parties. So we'll have political parties, a regulatory commission. The commission will be established through legislation, and matters such as the campaign financing and the proposed democracy fund will be addressed in that legislation, providing the flexibility a rapidly evolving field demands. On local government, on the election of district chief executives, the government has gone further than the committee. The committee recommended a phased approach under which the right to elect a DCE would be tied to a district's fiscal capacity, so that some districts would vote and others would not. The government takes the position that all district chief executives should be elected. Creating a distinction between voting and non-voting districts carries significant political costs and, of course, social costs as well, and may be perceived as discriminatory against citizens of non-voting districts. Under the government proposal, the president will nominate 5 persons, 2 of whom shall be women. Out of the 5, 3 shall be shortlisted, 1 of whom shall be a woman, after vetting by a committee drawn from the Ministry of Local Government, the Public Services Commission, and the Local Government Service. Those 3 will then be candidates for election as district chief executive or municipal or metropolitan chief executive. On the famous Article 71 office holders and matters of financial management. To deal with the question of emoluments of Article 71 office holders, the government has also accepted the establishment of an independent Public Emoluments Commission to determine salaries, allowances, facilities, and privileges of public office holders listed in Article 71. Those include the President and other Article 71 office holders, such as members of Parliament, the heads of the Electoral Commission, NCC, the judiciary, etc. The current arrangement, under which a committee appointed by the President determines the emoluments of office holders, including the President himself, creates a structural conflict of interest and has been a persistent source of public dissatisfaction. An independent commission will bring transparency and equity to this matter once and for all. On the public financial management, the committee made far-reaching proposals. It made proposals relating to the classification and annual reporting of tax exemptions as tax expenditures, safeguards on the contingency fund, a medium-term economic framework laid before Parliament, debt anchors and fiscal sustainability rules, an independent fiscal council, and so on. The government shares the concerns underlying every one of these proposals. Our position, however, is that they belong in the Public Financial Management Act and not in the Constitution. Fiscal rules must be adaptable as economic conditions change. The Constitution should state principles. The statute should carry the procedures. The government will accordingly bring amendments to the Public Financial Management Act to give effect to the recommendations of the committee. On fundamental human rights, the government has accepted the recommendations to abolish the death penalty. Now, that is already underway in Parliament with the Honorable member for Medina, the Honorable Francis Xavier Sosu, leading the charge. So it's not new, but the committee made a recommendation on it. The relevant provisions of Article 3, 13, 19, and 72 will be amended accordingly, and offenses that previously attracted the death penalty will attract life imprisonment. The death penalty is inconsistent with the constitutional right to life and with Ghana's international human rights obligations under the UN conventions to which we are parties. Now, let me spend a moment on what I consider, in my opinion, as a key pillar of the position paper. That is what I call the proposed Human Rights Act. the committee made numerous proposals to expand the rights protected under Chapter 5 of our Constitution, including economic, social, and cultural rights, the rights of women, children, persons with disabilities, older persons, and the youth, the right to health care, the right to housing, the right to a clean and healthy environment, the right to food in custody, and many more. The government accepts the spirit of virtually all of these proposals. But here is the difficulty. Chapter 5 is entrenched, and every amendment to it requires a national referendum. Subjecting each of these new rights to a referendum would impose a procedural burden disproportionate to the gain from amending the Constitution in Chapter 5. The Constitution itself, ladies and gentlemen, shows us the way out. Article 33(5) of the Constitution provides that the rights expressly mentioned in Chapter 5 are not to be regarded as excluding others which are inherent in a democracy and intended to secure the freedom and dignity of man and woman. Pursuant to that provision, the government will enact a comprehensive Human Rights Act. The Act will elaborate on the rights already guaranteed, extend protection to the new categories of rights identified by the committee, incorporate Ghana's obligations under the international covenants I have mentioned, to which we are party, and provide detailed enforcement mechanisms, especially, resort to the High Court for redress where a human right violation has taken place. The Human Rights Act will be justiciable. It will improve standards that, as we evolve as a society, and then as our institutional capacities develop. Most of the committee's recommendations on fundamental rights are going into the Act. And ladies and gentlemen, the Constitutional Review Implementation Committee will have as one of its tasks to be assigned by the President the enactment of the Human Rights Act. Since the coming into force of the Constitution about 33 to 34 years ago, we have not added to the rights in Chapter 5. We have usually used Article 33(5), as I've indicated, as expanding the scope of rights, but without a statute that spells out the fundamental rights that we are entitled to. In the same spirit, the government has accepted the recommendation of a constitutional right of abode for persons of African descent in the diaspora, subject to conditions set by Parliament, with a heritage-based pathway to citizenship. Ghana has a proud tradition of welcoming the African diaspora, and this provides a principled framework for the year of return and beyond the return. Parliament will legislate the criteria and safeguards, and measures will be put in place to ensure that the right is not abused. Now, I need to underscore one thing. We have taken the decision that the Comprehensive Human Rights Act, when enacted, there will be a provision in the Constitution that will prevent the Act from being repealed willy-nilly by any government, except where the government secures 75% of members of Parliament, the vote of members of Parliament, to repeal it. On the issue of corruption and accountability, the committee recommended the establishment of an independent anti-corruption and ethics commission with the power to investigate and prosecute corruption, and to assume the functions of the office of the special prosecutor. The government accepts the proposal in principle, but the objective does not require a constitutional amendment. The government will, through the Conduct of Public Officers Bill, which is currently before Parliament, establish a public ethics commission with the power to investigate and, in some cases, prosecute acts of corruption and conflict of interest involving public office holders and their collaborators in the private sector. Its mandate would be similar to that of the Corrupt Practices Investigation Bureau of Singapore, but unlike that bureau, it will be independent of executive control. Ladies and gentlemen, this briefing would be incomplete without me telling you about the changes affecting my own ministry. It is not every day that a minister stands before the press to announce the splitting of his own ministry. The committee recommended removing the Attorney General's authority to prosecute corruption offenses and recommended requiring leave of the court before a prosecution will be discontinued. So, in other words, where the Attorney General wants to or wishes to file a nolle prosequi or terminate a prosecution, the commission was of the view, or is of the view, the committee is of the view that the Attorney General should provide reasons before doing so. Now, the government proposes that Article 88 be amended to remove the requirement that the Attorney General be a Minister of State. A separate portfolio of Minister of Justice will be established to oversee the justice sector, the justice and legal sector. The Attorney General will remain the principal legal advisor of the Republic and the repository of the prosecutorial authority of state, but will cease to be a Minister of State and a member of Cabinet. And to guarantee the prosecutorial independence of the office, a new clause will be inserted in Article 88 to give the Attorney General the same terms and conditions of service as a Justice of the Supreme Court. This is a significant restructuring of the legal architecture of the executive, and I believe history will judge it kindly. In other words, whoever is appointed Attorney General after the amendments come into effect, if you want to remove that person, you have to go through the procedure enumerated under Article 146 of the Constitution. There has to be a petition, the determination of a prima facie case, etc., etc. I know that members of the media are used to this process, having followed keenly what has transpired within our republic. On constitutional amendment and the roadmap, government has accepted the introduction of a citizen initiative mechanism for constitutional amendment. Citizens will be able to propose amendments to the Constitution upon securing the support of registered voters, subject to minimum regional representation and gender balance requirement. The government proposes that the threshold be 10% of registered voters, rather than the 5% recommended by the committee, so that the mechanism is invoked only where a proposal commands substantial national support. The initiative will be triggered through the Council of State. The Constitution belongs to the people, and the people should be able to knock on its door directly when they show wish. Now, the roadmap is set out in this position paper for amendments of the Constitution, is set out in this position paper, and it is deliberate and time-bound. Following today's publication, the President will swear in the Constitution Review Implementation Committee. The CRIC, or CRIC, will prepare 2 constitution amendment bills simultaneously. The first bill will cover the amendments to the non-entrenched provisions of the Constitution. It will follow the procedure in Article 291 of the Constitution. That is publication in the Gazette, laying in Parliament, a referral to the Council of State for advice, and passage by 2/3 majority of all members of Parliament, followed by presidential assent. The second bill will cover the amendments to the entrenched provision. That bill must travel the road prescribed by Article 290 of the Constitution. It will be referred to the Council of State by Mr. Speaker for advice. It will be published in the Gazette for 6 months, laid in Parliament, and then submitted to the people of Ghana at a national referendum for approval. For a referendum to carry, at least 40% of eligible registered voters must turn out, and at least 75% of the voters must vote in favor of the Constitution Amendment Bill number 2 in respect of the entrenched provisions. The 2 draft bills should be ready by October 2026. And here, I should mention the practical reality. A national referendum is an expensive undertaking. To avoid the enormous cost of organizing a standalone referendum, the government intends that a referendum on the second bill, that is the Constitution Amendment number 2 bill, be held alongside the District Assembly elections in 2027, that is next year. We will work closely with the Electoral Commission and, of course, the Ministry of Local Government on the calendar for this to take place. Alongside the 2 bills, to amend the constitution as recommended by the committee, the government will bring the complementary legislative reforms I have spoken of, including amendments to existing laws such as the Public Financial Management Act, to give effect to the recommendations that do not require constitutional changes. In conclusion, ladies and gentlemen, countrymen and women, permit me to close with thanks. I thank His Excellency, the President, for his leadership in this process and for his unwavering commitment to constitutional reform. In fact, as I said, we had 3 rounds of meetings, including a weekend retreat. And His Excellency, the President, was present at each one of them and probably was the most alert person in the room. He gave leadership in terms of all the discussions on the recommendations. So I want to thank him for that, because he made some of the work that I have done very, very simple. Also, I want to thank my colleagues in Cabinet, including the Honorable Felix Ofosu-Kwakye, for their extensive input and helpful deliberations on the position paper. The document being published today is far richer for the scrutiny it received around the Cabinet table. And I thank once again the Constitution, Review Committee and its eminent members and its Secretariat, whose diligent work made this moment possible. I wish to also thank, put on record, my sincere thanks to my able and indefatigable deputy, the Honorable Dr. Justice Srimsai. Justice held the fort in the course of law from the Supreme Court to the High Court, and on a daily basis, so I can devote time and effort to the constitutional reform project and to the management of the affairs of the Attorney General's Department. That is what I call true partnership at work and the kind of division of labor that produces results. I cannot also end without thanking the junior lawyers in our Secretariat, especially lawyer Saeed Momin, for their tireless assistance in this project, and especially in the preparation of this position paper. The position paper and the final report of the committee will be published immediately after this press conference. Now, that is the headache of the Minister for Government Communications. I encourage every Ghanaian to read them. Constitutional reform is not a single event, but a continuing process. And the Constitution must remain a living document that responds to the needs and aspirations of each generation of Ghanaians. The next phase of that process begins today. Now, let me say this, that I have tried as much as possible to give you highlights. The government position paper itself is 89 pages, highly comprehensive, and some of the accepted recommendations have not been highlighted. So, as the media reports, please read the document very carefully. Don't go and take the highlights and say that government has rejected everything else. What we have done is to carefully examine, as I've said, the ones that are foundational, that go to the root of our constitutional democracy. And we have accepted those. We have also accepted those that we think should, the recommendation that, should be accepted with modification. Some of the recommendations we are putting in Acts of Parliament, and so the committee's work will be reflected in both the Constitution as well as the legislation of this Republic. The committee has done a wonderful job for the people of this country, and again, I want to record my thanks. So, ladies and gentlemen, that is it for constitutional review. And as I said, the process starts today. Thank you. Honorable Felix. Now, before I sit, let me do this. Sorry, thank you very much. I just wanted to show to our fellow countrymen and women the work of the Constitution Review Committee, the work of the H. Kwesi Prempeh Constitution Review Committee. Now, those who are in the media asking why government wasn't coming out quickly with the position of government, you should understand that this involved a lot of work. Personally, I had to read the entire document because I have to own everything that is said in the position paper. So I thank you.
Thank you very much, the Honorable Attorney General. So as he indicated, in the next few hours, we will publish both the full report of the Constitutional Review Committee and then government's position paper so that you can make informed decisions. And we urge the public to read. There's a tendency for people in our country to ignore facts put before them and then say other things. Some will not read even a line in the document and yet will purport to analyze it. In order that we put all the matters into proper context, we encourage the public to read the documents as we put out. Then you can set it against the positions taken in the position paper and then make an informed judgment. So at this stage, we will invite questions from members of the press on the issues raised by the Attorney General at this briefing. Yeah. Yes, please walk up to the microphone and ask a question.
So mine has to do with the separation of the powers. We were told there was a suggestion that MPs cannot be ministers of state, and ministers of state can also not be MPs. I would want to find out why was a suggestion like this rejected.
All right, thank you.
Minister, thank you. My name is Obed Kingaglu. I work with EIB Network, GH1 TV and Star FM. I have two questions, one on the constitutional review proposals and also one on the case of Senator Tamaklo. So on the first one, on the constitutional review, I want clarity with regard to the change in date for presidential elections. Is it the same for the parliamentary? Okay. And then for the second one, you've indicated your intention to file a stay of prosecution and of course execution. I beg your pardon, and then of course appeal. Given the huge public interest of this matter, we want to find out the timelines when you are going to do this. Thank you very much.
Thank you very much.
Thank you very much. I'm Sethi, GBC. Honorable Minister, you made mention of government accepting the recommendation to cap members of parliament. I want to find out, after every population and housing census, the Ministry of Local Government comes out with the creation of metropolitan, municipal and district assemblies. And then the Electoral Commission goes ahead to also create more constituencies. But I didn't hear much about what is being done, the amendment that is being carried out to ensure that whenever there's a population and housing census, the Electoral Commission and the Ministry of Local Government will not go ahead and create more constituencies and more districts. Then there was also this issue about the committee recommending the abolishment of regional tribunals. Not long ago, the government took a bill to Parliament and successfully established regional tribunals. I'm sure President has to assent to that bill. But then it didn't also find expression in the recommendations that the government accepts or rejects. Thank you very much.
Thank you very much. Yeah, Max.
Yes.
So maximize the time.
Yes. Maxwell Agbabajo from Joy News. My first question is on Sedina. So you stated that the states opposed the appeal, but the Court of Appeal overturned that conviction. A lot of people are curious to know what kind of defense did the state put up. Was it strong enough to let that conviction, stand? And then also, what do you say to suggestions that the decision to appeal the Court of Appeal's decision today is a face-saving one? And then my last question, on the Constitution. I want to find out, in a country seemingly polarized on partisan lines, I want to find out from the AG how he intends to build consensus to ensure that the Constitution review process, succeeds. Thank you.
All right, thank you. So we'll take the last one before the next round of questions.
All right. Good afternoon. My name is Julius, and I write for the Ghanaian Times. I have two questions, and the first one has to do with dual citizenship. The minister mentioned that if successfully, the Constitution, if successfully amended, dual citizens will be allowed to hold public office, but for the president and vice president. So I'll relate this to the battle he is going through to have Mr. Ken Ofori-Atta extradited to Ghana. If we go ahead and then allow everybody to hold every public office, apart from the president and vice president, how sure are we that we don't put spies in office? So, for example, imagine if Mr. Ken Ofori-Atta was an American. How sure are we that even the Americans wouldn't contemplate releasing him to us? That's the first question. So, what steps are in place to ensure that we don't have spies in office?
All right.
And then the second one, the CJ, the position of the CJ. Over time now, the removal of the CJ has become one topical one. So, for example, the CJ, the president, and then the Speaker of Parliament. But the removal of the CJ has become a bit easier, if you put it that way. To remove the Speaker, you need at least 3/4 of parliamentary votes to remove the Speaker. You need 2/3 of Parliament to impeach the President. But to remove the CJ, it's just a matter of the Council of States recommending that, okay, there's a prima facie case, go ahead, and then the President and whoever is involved, if they are convinced, after the committee recommends, the President must abide. What steps are we putting in place as a head of co-equal state arm of government? We don't just throw away the CJs, so that we have that balance in power. Thank you.
All right. Thank you very much. So the attorney now will answer these questions, after which we'll come back for further questions.
Thank you very much for the very wonderful questions. On the question of separation of powers, which relates to whether or not we should appoint ministers from Parliament. Now, the current system under the Constitution is a uniquely Ghanaian constitutional arrangement that married the pure presidential system of government operated in the United States of America, for instance, and the parliamentary system of government operated in countries such as Australia and the United Kingdom, etc. And so the idea was that there should be ministers drawn from Parliament so that the parliamentary experience, will be useful in terms of how government conducts its business or cabinet conducts its business. So it's a uniquely Ghanaian hybrid system of government. And we think that it has, there have been questions as to whether it has served us well, okay, and we think that it is the provision that says, look, the president must, appoint more than 50% of his ministers from Parliament. That ties the hand of the president, meaning that the president, whether he likes it or not, will have to appoint ministers, from Parliament. But the current arrangement, as articulated in the government position paper, I'm sure you would see the details when you read it, is that we prefer that the president should be given a free hand. So when the president comes into office, he can decide whether or not he wants to appoint just one member of Parliament as a minister, or he wants to appoint all his ministers from cabinet, which I think is not, no president will do that, because there will be expertise outside of Parliament that the president will need. but it provides a certain level of flexibility, and it still preserves the uniquely Ghanaian hybrid system, of government. Now, there was a second question which I didn't get quite well. The person started talking about Sedina Tamaklo, and I tried to motion to the person that, look, I have said it from the outset that this press conference is not about Sedina Tamaklo. It's sent to me. I have not read it. Professional decision, and I stand by it in principle that the appeal should be opposed. I inherited the docket. I inherited the extradition request, but government is a continuum. I reviewed the documents and I worked on them. So this is a principled stance, and it is a stance about accountability, okay, for this country. It's not about individuals. If it were about individuals, let me tell you, Sedina is my friend. She's my personal friend. It's not about personalities. It's about this country. And I'll take the appeal on to the Supreme Court. And to tie it on to the question about face saving, if you look at me, I'm not the type of person who fears losing face. All right? I am not doing this because I want to save face for either myself or the President of the Republic. I'm doing it based upon professional considerations and also on the advice of the excellent men and women who work with me at the Attorney General's Department. So we'll review the judgment. You will see the grounds of appeal, and I'm sure at that point in time we can all have a discussion as to whether or not the appeal has any merit. There was an issue also raised about capping of the members of parliament, and then the question of population quotas. If you look at the Constitution carefully, in terms of the designation or the demarcation of constituencies, the Constitution provides that the population quota be used as a measure of the decision, as one of the benchmarks for a decision whether or not to create a constituency. Now, the population quota, as defined in the Constitution, is usually one of the benchmarks, but it is not the only benchmark. If you cap the number to 300, what it then means is that you cannot increase the number beyond 300, but you can redraw constituency boundaries and district boundaries in order to take account of the growing population, so that you don't have a situation where some members of parliament, or let me say some citizens, are overrepresented whilst others are underrepresented. Now, what do I mean? So if we were based upon the population quota alone, I should not be an MP. Because Bolga is a very small constituency, and we have just under 35,000 when it comes to the voter population. Now compare that to Dome-Kwabenya, right? So whereas I'm serving just over 30,000 people, the MP for Dome-Kwabenya is serving over 100. The population there is very huge. All right. So left to the population quota alone, Bolga East should not exist. But the main point to be made for the decision of government to cap is that you cap it at 300, and if there is a need to redemarcate constituency boundaries, that will be done within the number that has been capped by the Constitution. Now, another person asked a question about the abolition of the tribunals. Well, if you read the government position paper, we have made clear what government's position is. The Constitution, as we have it now, establishes one integrated judiciary. The regional tribunals are currently part of the Constitution. If you read the Constitution, it is very clear In fact, the district tribunals have been, the district tribunals are also justified pursuant to Article 126 of the Constitution, which provides that Parliament has the power to create such, lower costs and tribunals as it may determine. I know that the predominant argument has been that the tribunals of the past were not the best when it came to the protection of fundamental human rights. And I keep saying that the tribunals that will be established pursuant to the bill that is, that has been passed by Parliament cannot operate like the tribunals of the past. They will be regulated by procedures established by law. They will also have to take account of the fundamental rights and enshrined in the Constitution, as well as the procedural safeguards that either the Constitution or statute will prescribe. So, for instance, I do not see how a regional tribunal can decide to overlook Article 19 of the Constitution on fair trial and then hope that its decision will be upheld when appealed. So I believe that what we are doing is in tandem with the letter and spirit of the Constitution. There is textual support in the Constitution for the bill. And if I may say so, there is also spiritual support in the Constitution for the bill. So I am not going to yield to those who are saying that the bill is not in the interest of the people of Ghana. Because the tribunals do one thing that ordinary courts do not do. They allow for the participation of citizens in the delivery of justice. And the Constitution is very clear that justice emanates from the people and must be administered in their name by the judiciary. And the judiciary is defined to include the regional tribunals and such lower courts or tribunals as Parliament may by law establish. Go and look at Article 126 of the Constitution. I've answered the bit about saving face from the Sedina matter. There is also a question about building consensus, given the fact that we are a very deeply divided and polarized country. Now, the level of polarization in this country is at, I agree, is very high. I also agree that it is at the level of the two main political parties. And so, in coming to this point of the constitutional review, I have tried my best to build bridges across the divide. I wrote to Parliament as a co-equal branch of government, and I submitted the report, the final report of the H. Kwesi Prempeh Committee to the Speaker. I also wrote to the Majority Leader, the Honorable Mahama Yarga, and gave him a copy. And I wrote to the Minority Leader, the Honorable Afenyo Markins, and gave him a copy. I reached out to the minority and requested that they give me a name to serve on the Constitution Review Implementation Committee. And I was given the name of the Honorable Member for Asante Achim, I think Central, that is the Honorable Kwame Imedu. Is it Central or South? Central, yes. So hopefully he will be there to represent the minority. And then also we have a member of the majority caucus being there. And we have an eminent justice of the Supreme Court who will be the chair of that committee. So I have started building the bridges. And let me tell you something. This constitutional reform project is a national project. All right? Under His Excellency Nana Addo Dankwa Akufo-Addo, there was a Constitution Review Committee which was spearheaded by the then Majority Leader, the Honorable Che Mensah Bonsu. I sat through the proceedings of that committee, I made my views known. I was then in the minority. I was a member of the minority, the opposition. But I sat through and I made my views known. So my hope is that being a national project and with the good intentions exhibited by His Excellency the President, will all come around the table, because the amendments that are being proposed are supposed to enhance, or let me say designed to enhance our governance. And if you look at the Constitution is very clear that governmental power must be exercised in the name of and for the welfare, underline the word welfare, of the people of this country. That includes, members of the minority. And I'm hoping that they will come around the table for us to all think through what is doable, what is practical, and what will inure to the welfare of the people of this country. Also, there's a question about Ken Ofori-Atta and the dual citizenship, and whether we will not be appointing spies into office. Well, to be honest with you, and I'm being very, very candid, all right, I have not thought about the question of spies in office. I trust that any of our citizens who has the citizenship of another country and wishes to offer public service will do so in good faith, all right, and with fidelity to the laws of this country. And it is not only dual citizens who can be spies. Citizens, people who do not have dual citizenship, can, because of material and financial considerations, turn themselves into spies for other countries or agencies of those countries. In our history, the CIA didn't pay dual citizens to overthrow Osagyefo Dr. Kwame Nkrumah. If the people who did so, who betrayed him, had dual citizenship, I do not know. But I can tell you that the fact that a person has dual citizenship does not diminish their loyalty to this country. And so for me, I will stand by it. It's something that is long overdue, and we should be doing it. Now, should we be, saying that, I don't know what the link is with Ken Ofori-Atta. I've never had any doubts as to whether he was spying for the, CIA or any entity. And that is not my concern at all. It's not my concern. And given the situation in which we find ourselves, I would want to stay away from commenting exhaustively on the issue of Ken Ofori-Atta. There is also the question about the removal of the CJ. I think it's a legitimate question. Article 146 is not that simple. It provides a regime for removing the CJ on stated misconduct. It does not say that the president can, by the stroke of a pen, fire the CJ. It doesn't. It prescribes a procedure for determining whether or not the stated misconduct has taken place. But of course, there have been concerns raised about what has transpired recently, and I have noted those concerns and will be, as I said, refining the rules and elaborating on them to make it probably more, not that more difficult, okay, but just to ensure that there are no doubts raised when it comes to the removal procedures, or the removal of a Chief Justice. But you are very right that the judiciary is a co-equal, a branch of government, that the Chief Justice is an officer of state who should not be removed very easily. Okay? I do agree with that underlying principle. But was the current, the Chief Justice, the former Chief Justice removed easily? It was not. Thank you.
Thank you very much. So, no, nobody who has asked a question is coming back. We need to save time. So, the three of you who have not asked any question can ask any.
Okay.
Max, you have the opportunity. In the next 10 minutes.
No. Good afternoon, sir. I'll make it this very quick. The first one is on the referendum. You propose that you do it alongside the district assemblies elections, which is somewhere next year. But we would need 40% turnout for this referendum to succeed. The district assemblies elections are notoriously having low turnouts. The last one was 37%. The one before that was 35%. Are you not shooting yourself in the foot by putting this all-important amendment that you say you support alongside the district assembly elections, which normally will have a low turnout? If that turnout repeats itself, it means that your referendum will fail. How are you doing that? Don't you think it would be good to do a standalone referendum, even though it will be expensive, so that we know that we have succeeded? I would like you to clarify that.
Thank you very much.
I have just one question again.
Make it snappy, please.
On dual citizenship, it's not only Mr. Knofriata who is away. I don't want to bring that issue back. But Mr. Akoli is a dual citizen. And I've not heard us even ask questions about him, because we know that it is totally impossible. We won't get him.
How do you arrive at such a conclusion?
Because even Mr. Ofriata, who is our own, a Ghanaian citizen, we're having issues. I read that a court in America said there is no basis, despite all that we have done. So imagine their own citizen. What's the principle that MPs, Attorney General, who will now will have the tenure of a Supreme Court judge, can be from principle? What's the difference?
All right, thank you.
My name is Kwame Asante. I work with Oni TV, Oni FM. My question is simple. With the proposed month of November that the Honorable Attorney General said they are proposing that we should have the general election, the election of the President, and then that of the members of Parliament in November. Is there a proposed fixed date in November that election will be held? We know it was December 7.
I thought the AG answered that, but anyway, he will take the opportunity to reiterate it here.
Good afternoon. My name is Romeo Tete, and I report for Ahonto FM. Honorable AG, please, we want to know the number of recommendations made, especially on media reforms. How many of those were accepted and how many were rejected, and if any reasons. And please, lastly, for the avoidance of doubts, when is the new changes of the president's term in office starting? Is it starting from the current president or the one that comes after him? Thank you.
The AG was very clear that it does not apply to the current president. Thank you very much. Okay, Max.
Thank you very much. This last question is in the spirit of oral. Yeah. No, so I just want to find out from you, Honorable AG, you've made known your intention to appeal this decision. I know that in the spirit of double jeopardy, if it fails at the Supreme Court, we cannot continue. Would you be willing to bring fresh charges against Sedina if the appeal fails? Would you be willing to bring fresh charges? Thank you.
Yeah. Okay. Thank you very much for a second round of excellent questions. As I indicated earlier, I would employ all of you to read the government position paper thoroughly as media people, because it's very, very comprehensive. Now, on the referendum, the concern that you have raised about the 40% threshold is a real concern. But again, from the statistics that you have put out, the district assembly elections usually attract very low turnout. Okay, so if we were to just tie it to the assembly elections and rest it there, then you can be sure that we may not be able to get the 40% threshold prescribed by the Constitution. But the referendum is a key aspect of the legacy of His Excellency John Dramani Mahama. And therefore, there will have to be, educational activities by bodies such as NCCE regarding the referendum. Of course, I'm sure civil society groups will take part in whipping up support for the referendum, given the fact that it is supposed to, it is designed to ensure that we put through these constitutional, amendments that are designed to ensure that our country is very well governed. So the threat is real, all right, but I don't think that it is a threat that we cannot overcome. So a standalone referendum for now is not what we are proposing. We'll work with the EC and then the Ministry of Local Government and Chieftaincy and Religious Affairs to see what date will be fixed, and then we can take it from there. Now, there was a question about Mr. Akoli, all right? I think of the two, because Ken Ofori-Atta was a Minister of State, our former Finance Minister, there's always focus on him. But the request that has been sent by my office includes that of Mr. Akoli. And now, take it from me, all right? The fact that a person is an American citizen does not immunize them from extradition, all right? So, American citizens can be extradited to Ghana, all right? Well, the fact that it has never happened doesn't mean that it cannot happen. But I'm telling you that from a legal, technical point of view, the position that you have taken is wrong. The fact that somebody is a dual citizen doesn't make it difficult, doesn't, put a roadblock on the way to extradition. Even if that person is not also a citizen of Ghana, they can be extradited to Ghana to stand trial. All right? Then there was a question about why the distinction between, offices. I think that the discussion excluded the high offices of President and Vice President of the Republic. All right? I believe that if somebody wants to rule this country, okay, they should be in a position to say that, look, I do not want to be the citizen of another country. And I think that that is probably the basis why those two positions, in fact, even all the civil society groups that have campaigned on this, there is a bill to amend the Constitution that is currently being considered by the Parliamentary Committee on Constitutional and Legal Affairs. And in that bill, people like Professor H. Kwesi Prempeh, as well as Professor Kogu Asari, have agreed that the two high offices of state, that is President and Vice President, should be left out. But I want to also let people know that historically, for instance, we had Justice Apalo, who was a chief justice of this country, okay, leaving Ghana and becoming Chief Justice of Kenya. He was a Ghanaian citizen, but he was appointed Chief Justice of Kenya. Okay, so these are matters that I think the CRIC will look at. They will be debated in Parliament, subjected to a referendum, and eventually will come to a position as to whether or not we want to go forward with them. Then the question about proposed fixed date in November. I said we will consult with the Electoral Commission to be able to determine what that date should be. So we don't have that, and the government position paper did not specify a date for the elections. There are a lot of recommendations on the media. Of course, you cannot have the Honorable Felix Ofosu-Kwakye around the cabinet table and not expect that recommendations regarding the media are included in the position of government. And so there are recommendations, for instance, on the National Media, Commission and its role in the regulation of the media in our country. Those recommendations are contained copiously in the report. Then also, the last question that touches upon the government position paper is on the term of the president. All right? I made it clear that this is forward-looking. Okay? It's forward-looking. We have proposed that the 5-year term be the term of the president when the president is, elected. All right? Now, if we look at it critically, and the term of parliament has also been, we have stated quite clearly that the term of parliament should also be enhanced to, 5 years. All right? The question whether it should apply now or should apply, in the future, and whether, for instance, Parliament can decide that in passing the legislation that its life be extended by another year. Those are all matters that will be hammered out when CRIC begins its work and Parliament begins the process of enactment. Will I bring fresh charges? That is legally impossible. After the Supreme Court speaks, I don't see how I can bring charges. Fresh charges. Yes, unless the evidence is different. Unless, yes, if I get fresh evidence, okay, of wrongdoing, that would be an entirely different kettle of fish. From saying that based upon the same charges, I'm going to arrest her after the Supreme Court has made a determination. Either way, let's say the Supreme Court says that the High Court was wrong, or it affirms the Court of Appeal. I cannot legally, I'll be legally barred. Okay? But as I said, I don't want to comment on the substance of the appeal. We will publish the arguments of my office that were filed before the Court of Appeal. And again, subsequently, when we file our appeal in the Supreme Court, there will be public documents. And for those of you, the media houses that have lawyers, I'm sure they will read them and determine whether I am right or I am wrong. But I have taken a principled stance, and that stance will go forward. I thank you for your attention and for the wonderful questions. Thank you.
So thank you very much, Honorable Attorney General, and thank you all for coming.
Some of what have been accepted subject to certain changes, and some of what will not be considered at all. And if I'm able, and let me introduce my guest once again. You've already met lawyer Zachariah Tanko Musa, who is also a lecturer at UNIMA. But let's welcome Dr. Abdul Jalilu Atiku, who is also a lecturer at the Political Science Department at the University of Ghana. Doc, welcome to the panel, and I'm sure that both of you, we've all listened to what the Honorable Minister went through by way of the summary of the government white paper, and I also want us to just quickly go through some of the things that he said. So he started off with the three ways that this can be analyzed, whether government was accepting or accepting in principle, subject to modification, or not to accept at all. And he said that the principle really is that only those changes that required constitutional amendments were added to that white paper. So on some of the accepted terms, he went through a number of them: the extension of the presidential term limit, removing the age limit from 40. The recommendation was to make it 30. He said that government has accepted to put it at 35 so that it will be in line with what applies elsewhere. Make sure that the person attains some level of maturity and experience before they even attempt to hold public office. Elections, he's told us the suggestion is that they should be held in the first week of November, with the Electoral Commission expected to make the announcement of what the definite date should be, and then let that be public. The election of MMDCEs was also very topical. Article 71 office holders and the determination of their salaries and emoluments were also mentioned in there. And I'm sure that you also listened to the vast array of things that the minister went through when we heard him speak from Jubilee House. I want to start this time with Dr. Jalilu, because you've only recently joined us. And I want to ask which of these you find most striking. Are there any surprises in this submission for you?
Thank you very much. I think we must commend the Constitution Review Committee for their work, because if you, listening to the Attorney General and Minister for Justice, I think that I would say that maybe about 80-90%, right, of what they wanted, they proposed have been accepted, and the few have also received some, maybe they want some amendment, all right, or there have been some modification, all right, so not completely rejecting that, all right. But they talk about the November, having our elections in November, and I think that is very important, okay, in the sense that, if you look at the time frame, and sometime we may have a presidential runoff, right? And from that period, okay, to when we are supposed to hand over the transition, right, is so close that sometimes things are done in a very hurried manner. So if we hold our elections in November, I think that is a good thing. It's not the first time. If you recall, 1992, we had elections in November and then December. Parliamentary elections, presidential elections were held earlier, and then parliamentary, and then with the boycott, and that was how come we now have both on the same day, right? So having the elections in November, I think that is a good thing, okay, right? Yeah, and it's only I have issues with the appointment of the MMDCs, okay,
or the election of the MMDCs.
Exactly. So I expected that it should be, MMDC should be elected, right, as it has been proposed. I think it's not the first time. If you recall, President Atta Mills had, the Constitution Review Committee, the committee made similar recommendation that should be election, and then the government white paper at the time also accepted that there should be 5 people who should be sent to the president, just as what we are experiencing. From
so
what
just
we
to
have,
go
we have
through
now.
What the AG said, he said that even though the committee had recommended a phased approach under which the right to elect a DCE would be tied to a district's fiscal capacity, so that some districts would vote and others would not, and the government takes the position that all district chief executives should be elected, creating a distinction between voting and non-voting districts carries significant political costs and may be perceived as discriminatory. And he went on to say that under the government proposal, the president will nominate 5 persons, 2 of whom shall be women, and out of the 5, 3 will be shortlisted, 1 of whom shall be a woman. So shall is important here, and lawyer will explain into detail why. So 1 of them shall be a woman after vetting by a committee drawn from the Ministry of Local Government, the Public Services Commission, and the Local Government Service. Those 3 will then be candidates for election as district chief executives. So technically, we are not electing a DCE from scratch, or we've not been told whether people can put themselves forward. What we have been told is the president will nominate 5. So the president is still technically choosing. Yeah, so the president will still have a hand. And that's where I have a problem that I was thinking that this time around will allow all MMDCs to be elected, and then it should be conducted in a partisan manner. Because, from you wanted their election and for it to be partisan. Because we cannot have national elections that are contested on a partisan basis, and then we still have our grassroots where you have a kind of, nomination before all these processes before the election. So I was thinking that, just like we elect the members of parliament, MMDC should be elected the same way. So that's one of the issues that I have with it, and also
for the 300, MPs, I was thinking that the number was too much and we should experience we should have some, reduction. Okay. But now it's being capped at 300, okay? Yeah. And the 300, and the reason, why I will accept this is that they are talking about the fact that maybe
a proportional representation
that will draw in other minority or groups, right? Mm-hmm. Like women, disabled, or those.
It said so women, persons with disabilities, and exactly. The youth.
So I think that that's a good point. Okay, so when we have that, I think that will also be good. But and I'm not a fan of the 4 to 5 years presidential term limit, right?
Why not?
From 4 to 5 years. 4 years is 4 years. You come, when you perform, you will be re-elected. If your party performs again, you can get 12 years, right? Because we have experience, the few period that we have operated it's 1992 over the past 30 years. Okay, sometime, right, you get to a point where, if you look at the hardships, the tensions, right, then it means that you still have that same president going to have another 1 year. So for me, I think that like the 4 years was okay, 4. If you are able to perform, the next time you can be, you can be, your party can be returned to power rather than 5 years, that's 10 years. I think that is something, yeah.
Okay. Thank you. So this is what the AG has said. And it's interesting that he could be one of the last serving attorney generals and ministers of justice, because he has said that the government accepts, with some modification, I think, that the office of the attorney general and the Ministry of Justice should be decoupled. And what were the standout moments or highlights for you in this address?
Oh, a number of them. I have been, almost all the time in my class, I asked this question about the age limit and about the whole concept of indirect age discrimination. But here again, you still have, if you like, adults still determining who can be president at what age and all that. Now they are capping it. They say you can now, they've reduced it from 40 to 35. Yeah. But that of parliament is still open. So if at the age of 25, I can put myself forward and be elected as a member of parliament.
If at the age of
18, I can put myself forward and be elected and go and make laws. And yet parliament is another arm of government and all those things. So for me, I don't know, but
you think it must align?
For me, I think there should be some alignment. Because at the end of the day, members of parliament are people's representatives, and the qualifications to be a member of parliament is almost similar to those qualifications of being a president. But here again, we are trying to look at the middle ground. But if you look at 35, that's basically the middle ground. If you look at, I think Pew Center for Research or something, they came out with some general overview of the average age of world leaders and all those things. And 35 seems to be the middle ground. So I take that. The other thing was for me about
the president. Did they find the 5-year term striking?
You remember before that, I had said that if you look at the first year of a government, it is almost wasted trying to form government.
And the minister made those saying.
And then the subsequent last year is also. So there had always been that challenge and all those things. But for me, increasing it to 5 years without coming out with the legislation to deal with issues about campaigning period and all those things would be actually meaningless. So if we are going to increase it to 5 years, then we have to also introduce a statutory legislation that would have to regulate the way we go about campaigning and then the period where that government would have to put up an order. So for me, it is not a bad idea, but it is about whether we are going to come in with, if you like, a supporting legislation to make it more meaningful.
Will the proposed political parties regulation commission be able to tackle a concern like that?
So that they would have to look at party financing, period of campaigning, the amount of money we use in. They will cap all those things and all that, and that can then make this 5-year thing a bit more realistic and all that. But if we don't do that, we're still going to end up having those challenges.
Did you find it interesting in any way that he had to reiterate that for the avoidance of doubt, the recommendation, if approved, will not apply to the current president, but for future presidents only, this 5-year term.
Well, because before that, a lot of people had always indicated, even when the Constitutional Review was recommending that, people were thinking, are you doing it to favor the incumbent government and all that? So, I mean, it's fine, but I don't think that would have been a reasonable thing to do. But he made also the point that Parliament, in trying to look at, because it is also going to apply to Parliament and all that, whether parliamentarians would choose that they want to, you know, extend their stay by another year, that would have an uproar. I don't think that is the way to go. I think we should let it take effect from the next elections. There was one thing that I really like, the obligation on the Electoral Commission to disclose issues that had to do with electoral petitions
to
and
all
parties. To all parties. Because remember, we had that problem in the last petition when the Electoral Commission was accused of refusing or failing to provide certain information to the petitioners to help their case. And if we are talking about making sure that the will of the people is manifested, then every little information that would help us to get to the bottom of the matter should be actually brought out. So that disclosure for me is very, very crucial. The other thing that for me was also very crucial was the fixed tenure of the CJ.
10 years.
The 10 years of the CJ. So, whichever comes earlier.
Whether it's retirement
or
in the judicial services at the age of 70, or him serving the 10 years.
So if you are 50 years and then you are made a Chief Justice, when you hit 60, you have to give way, although you have to retire at the age of 70 years.
Then what do you retire as? Because if once you've served as Chief Justice, if you are not 70 and your 10-year time expires, do you serve as a Supreme Court judge?
If you retire as a Supreme Court justice and you get the emoluments that comes with it. But the question would be that, so when you retire, when you finish your tenure of 10 years and you are not yet 70. Do you go back and become? But remember, the Supreme Court had actually made a determination on that when the former Chief Justice was trying to say, well, removing me as a Chief Justice doesn't mean. They say that it is almost that is. So this is some of the nuances that we have to look at. So it means that technically, if you look at what the Supreme Court decided, if you are 60 and you've served your 10 years, then that means that that's it. You just retire and then you say bye-bye to the bench.
But they're also capping the number of justices to... the committee recommended the capping at 15. The government is proposing 19. So it's the Chief Justice and 18 other justices who are...
So you need to...
if there's already 19 of them and then one person retires, if we need a new Chief Justice or a new one to be named, then can you go back to being
if the Chief Justice goes on retirement, remember before retirement there would be attempts to try and do a succession and all that. But you see, capping the number of the Supreme Court judges would also have to come with looking at certain, exclusive jurisdictions that they have. In other words, issues about having the exclusive jurisdiction of interpreting the Constitution and all that. So you have to either look at whether you're going to reduce the sort of things that they have to deal with, because if you don't do that, then that 19, you're just going to end up banning them, and that would have a counter productive
But wouldn't the AG know that? Because he's an astute lawyer of many years, reputation.
But the AG doesn't get... The AG would make his recommendations, but his recommendation is not going to be, the dominant thing. But what the point I'm making is that the 19, I mean, it's not bad, because if you look at where we are going now, where there's no cap. But I'm saying that if you're going to cap it, then you have to also try and make sure that you are mitigating or you are taking away the sort of things that would make them be inundated.
And that's what I'm saying. That. So the AG would know the weight of the work that the current Supreme Court justices face. And so he would know better than perhaps I would whether 19 of them can hold the fort at any particular point in time.
So what are you suggesting? That the AG's views may have been taken on in determining the 19?
I'm suggesting that in determining to cap the number at 19, the AG would have taken into consideration their workload and agreed, or the team would agree that 19 of them, considering the work that they have, can still do the work as effectively as...
Agree with who?
Agree with the panel who agreed, who arrived at the 19 number.
Well, but that's why I'm saying. That's why I'm saying that everybody else made recommendations to the Constitutional Review Committee. It's possible that they met the judiciary. So it's possible that when they made, the judiciary may have proposed that, well, looking at things, 19 is okay, or maybe 17 is okay, and then the government has said that. But what I'm saying is that whatever it is, you know, looking at the numbers we have now and the challenges they are facing, for me, practically, that 19 is feasible, but it can only be feasible if you also know, because now, anything that has to do with the interpretation of the Constitution, you know, the first point of contact is where? The Supreme Court, which is the highest law of the land. You will rush to them for something as important as what? The interpretation of the... In other jurisdictions, they have constitutional courts and all those things, where they will travel through the normal court hierarchy before they get to the Supreme Court. And so we have to look at all these things, you know, and then make sure that we are not solving one problem and creating another problem as a result. So that's why I was attracted to the submission by the learned Attorney General that they would also make sure they are coming out with what? Legislations that would actually complement whatever they are putting there. There was also, and you mentioned the issue of the independent body to regulate the political parties. That is very, very, very important, because we cannot continue, because especially when they talked about the fact that every registered voter should be allowed to vote and all that. If that is the case, then there should be an independent body that would look at the way political parties conduct their affairs, transparency in terms of their finances, who is financing you, how much you are spending in campaign and all those things, and even cap campaign expenses and all that. Because all these things about now, the political parties are arguing that, well, you say everybody should do that. How are we going to do it? It's going to be expensive. Who says elections should be expensive? During the COVID, did we not see that we were not having face-to-face rallies and all that? So it means it can be done. It's just because we have made it to look like that. But it can be done where you really don't need to be going to every district, every constituency. You can do a regional rally once and that's it. It's about the message, right? At the end of the day, we say power emanates from the people and that we are the power. So if eventually this party says, I'm not giving money, another party says, I'm not giving money, those who want to vote should come and vote. Those who won't vote shouldn't vote. The small that would go and vote would determine the leader. And by and large, that is the way you challenge, if you like, positions that are not helpful. But if we just throw our hands in despair and say, no, we have to start somewhere. So for me, I think this is a very important proposition. The bit about the MMDCs, yes, my brother was right. I mean, if you want, the argument was that let's make it partisan. There was that argument because now it's almost like a flu. We know that behind the scenes, indirectly, political parties support candidates.
Sometimes openly.
Yeah.
And by their...
Right, and I know it from a very practical perspective, what happens and all those things. But I'm saying that if we are going to make it elected, I am a bit surprised about the propositions where the president would nominate and then, you know, 3 people would be made available. But maybe that is an enhancement or from where we are now, where ultimately the people get to decide who their member of parliament is. And when they know that...
But we are told who to choose from.
But they are giving you a pool to choose from. And then you get to choose. So that is a bit of a movement. But for me, I want to see whether... because that may not be made... Because, you see, this is the problem. It is an entrenched clause. So now getting to change it again might take us another how many years? If it was not an entrenched clause and it is something that could be changed through a legislative instrument, an act of parliament, then yes, as we go along and we are, you know, perfecting it, we could do that. But that's my only concern for that. The other thing was, I think, the issue of the OSP, where the Constitutional Review was saying make it a constitutional, if you like, issue. But they are saying, no, we don't want to make it a constitutional issue. This can be done through an act of parliament. But we know how our parliamentarians have behaved over the years. The partisanship. So for something as important as the office of the special prosecutor and what we want the special prosecutor to do, I would have wished to see it actually in the constitution and giving that person that sort of safeguard. Because we see what just happened, you know, where an attempt was made to strip the office of the special prosecutor of its powers and all those things. And even a high court even actually says that almost all the cases they were doing, it took the Supreme Court to say, no. So if we can put it in the constitution, for me, I think that would be amazing. So for me, that I have a problem with.
Okay.
There was another issue that that caught
I wonder if it's about the emoluments and the president's salary and the salaries of the Article 71 official there. Any surprises there for either of you?
No. I think.
Okay.
Yeah.
So the suggestion is that the president's the Public Emoluments Commission should be established, an independent Public Emoluments Commission.
For me, I think that is long overdue. But the one that caught that for me, the citizen initiative. The citizens' initiative, the mechanism to amend the constitution when 10% of citizens say it should.
And that has gone up from 5%.
5% to 10%. At least we are making a headway. Because certainly, you know, this over the last 30 years, how many times have people not been crying about certain provisions in the constitution and nothing has been done? But we can only achieve this if we are able to also let the citizens create the avenue and the opportunity for people to be involved. That's civic responsibility. We need to introduce that so that people can take that up. But for me, I think that when it comes to some of the amendments that Parliament can do, this is why I am really excited, because if we really want to do it, it is good the Attorney General wants to get consensus so that we can get these things passed. But if the consensus doesn't come and the political parties want to do partisanship, once the citizens of Ghana, once Ghanaians say that this is what we want, I think the government that they have given their mandate to overwhelmingly has that mandate in Parliament to be able to go ahead with those ones that are not constitutional, that are not entrenched constitutional requirements. So if they want to do it, they can really do that easily. And I think it makes sense to also run it alongside the local elections in 2027. But remember, the local elections had always have very low turnout and very low
one of the journalists raised
enthusiasm.
But if 40% attendance is required for a constitutional amendment, and we are having figures lower than 40, 35%, sometimes even lower in other elections, how do we ensure that we drive enough people to go to the polls to have a credible enough number to vote yes or no?
So the prompting, there has to be a lot of, you know, if you like, promotion of the whole concept of the referendum and what it means and why citizens should be involved. And I think that is where government has to spend some resources to support the various, you know, if you like, blocks that would come in terms of what position they take regarding the referendum that is going to be put before the people. And I think that we should be able to make it. I think we should be able to achieve that 40% or more.
Okay. In recent history, from the plebiscite that we had during the creation of the
new regions,
we had 80% range. If you look at all the 6 new regions, people voted, they went out and then they voted. So I believe that with if they are able to communicate well to citizens about some of these issues, people go out to vote. So there are recent history demonstrate that people will be willing, people will go out and vote.
Okay.
You know, there is this very important point which actually has been bedeviling us, this issue about noli prosequi, which is the preserve of the Attorney General, and they are not supposed to give reasons why they are entering a noli prosequi. And it has been subject to abuse, political, you know, patronage. Now there is a recommendation there which have been accepted that if he has to, he needs to be able to.
Say why.
For me, that is very important. That is very important because this concept is a concept we borrowed from our colonial masters. We have held on to it, and it's been in the constitution, and we use it in a way that is really not legitimate. That is not to achieve a legitimate aim. For me, this attempt to get it to be independently verified and all those and justified is something that would help us to move away from a situation where when one of your own is being subjected to, if you like, legal scrutiny, and you see the road is almost at the dead end, then you enter nolli prosequi and get the person out. That is one of the things that does not engender
the minister
trust.
said that the Attorney General who sits in cabinet cannot comfortably prosecute members of the government of which he is part. And so later on he goes to say that he will remain, the AG will remain the principal legal advisor of the Republic and the repository of the prosecutorial authority of the state, but will cease to be a minister of state. And that he went on to say, to guarantee the prosecutorial independence of the office, a new clause will be inserted in Article 88 to give the Attorney General the same terms and conditions of service as a justice of the Supreme Court. What does that mean in effect? What kind of power does he then assume or lose with that amended clause?
It's a very important power. It means he has security of tenure. It means that you can't just remove him. If you want to remove him, you have to go through those very stringent processes, unlike now where really the government, he who appoints cannot disappoint. So that's very, very important. And I think that is something that, but this is one of the portfolios that almost all governments have agreed that it should be decoupled. But they only say that when they find themselves in opposition, or when they are in government, they forget that that was what they were conversing when they were in opposition. So for me, I think it's a very, very important thing. But the point about ministers, also members of parliament, also being what?
Ministers.
MPs. I am excited because I have for years been arguing that it is not for any reason that the framers of the Constitution says take majority of members from parliament. The idea is that when you go to the people and say, this is what I want to do for you, and the people give you their mandate, you should be able to come and execute the promises that you've given to them. So you should have members in parliament who, when you bring legislation, because the seat is you in government, they can appreciate where you are coming and they would support you. Now, the problem I had is where you are tying the hands of the president and saying, take a majority from that. I think you should give the president that leeway to choose. But, I mean, separating it totally too is a problem, because I am saying that because I witnessed when there was the credit crunch in the world. At that time, I was the CEO of the minority group in Sheffield, and we did some research. And it took the UK a very short period of time to get the bailout, because members of the parliament were also part of what? The exec cabinet. So they were able to go there and quickly get it. When it came to the US, it took them ages because of the total separation. So they were fighting and all those things. And remember...
So our unique situation has its benefits.
It has its benefits.
And it also presents
exactly
the challenges.
And you see, if you also say that no member of parliament should be, then you are creating that difficulty. And you saw what happened even when we had the 137.
Okay. Doc, I think wants to add.
I will go for a strict separation of powers between the legislature and then the executive. No, if you look at our parliament over the years, okay, once the president, if you look at the constitution, I mean, what we have is Article 78 or so, the president must appoint majority of ministers from among members of parliament. All right, so it means that every parliamentarian there is a potential minister. The person in parliament who is supposed to scrutinize government activity for the people of Ghana.
It's also
that person is part, and that person is also looking for opportunity to be noticed by the president for appointment. So virtually you have, that's why you always have largely members, I mean the government parliamentarians from the ruling party who always want to approve everything that is coming from the government, right? So you have then the opposition who will be doing, and in this type of parliament that we have, where the opposition members are just about 88 or is it 89. So virtually you find most of the decision going through, because so the only thing they can do is mostly working out. But when you have separation of powers, right, it means that, because if you want to become, if there's strict separation of powers, you want to become
MP.
An MP, a minister, you must resign from your position. So when you are there, you are not there to serve
the interests
of the executive, but to scrutinize government, activities, bills, finances and everything.
Yeah.
Right. So yes, they may. Definitely there are disadvantages when you have strict separation, and then even when you also have the parliamentary system where you have like maybe every person. Like even in our situation, we have. If you look at that, it's just Article 78 and then Article 88 that ties us. Other than that, but in my view, I thought that we were going to decouple them. But if you want to be, so that you can, if you want to be, an MP, parliamentarian, you build your capacity. Whether to become a career, and then you are there.
This is my fear.
Government accountable. For the people of Ghana. So I think that is
perfect submission. This is my fear. In other jurisdictions where they have total separation, they have legislation, acts that actually defines issues about lobbying and all those things. Now we live in that part of the world where if you make members of parliament absolutely independent. And we saw what happened when Parliament was 137. Basically, what you are going to succeed in doing is that you're going to have a situation where members of Parliament will be on one side, as against government on one. And what you are going to do is introduce lobbying. Lobbies where people are going, I want something to be passed, I want a tax exemption, go to Parliament, get some members of Parliament, lobby them, and then they know that. So that's something that it's a very good thing, but I am thinking that we shouldn't just brush it aside. It has both positives and negatives, but looking across for now, I think that the positives far outweighs the negative. Let's start with this, and then we graduate.
Thank you so much for the thoughts you shared. From what the minister said, following the publication today, the president will now swear in the Constitution Review Implementation Committee, and they will prepare two constitutional amendment bills simultaneously. The minister says the first bill will cover amendment to the non-entrenched provisions of the Constitution, and the second bill will address the ones that concern the entrenched provisions of the Constitution. So this is by no way an end to the matter. As he said, it is a continuing process, and at another opportunity, I'm sure that if not these exact guests, the platforms will have the opportunity to interrogate some of these matters in a bit more detail. But let me say massive thank you to Dr. Abdul Jalil Atiku, lecturer, Political Science Department at the University of Ghana. Thank you so much, Doc, for the perspectives. And lawyer Zakaria Tanko Musa is also a lecturer at UNIMAC. And thank you also, Counsel, for, as always, the perspectives that you've shared. And I wish you a very pleasant day. Thank you for being a part of this coverage. We'll pull the curtain down here, but I'm sure we'll have another opportunity on GBC's platforms to engage once again on these and other matters. I am Thelma Taki. For the entire production team, we say bye-bye for now. Thank you for watching.